Georgia's broad racketeering law may now ensnare Donald Trump. In 2013, Fani Willis served as the lead prosecutor in what is still the longest criminal trial ever held in Georgia. Teachers and administrators in Atlanta public schools had been accused, a few years before, of cheating on standardized tests. A special report commissioned by Georgia's governor concluded that 178 educators, including more than 3 dozen principals and a superintendent, had participated in organized and systemic misconduct since at least 2001. Teachers were giving children answers and altering incorrect responses, investigators reported. Administrators were offering financial incentives to those who abetted the cheating and punishing those who did not. One teacher, who admitted to changing test answers, told investigators, "APS is run like the mob." The Fulton County District Attorney's Office agreed. The county indicted 35 educators and administrators for conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, or RICO, a statute that, historically, is associated with the prosecution of mafia figures. Willis, in her opening statement, explained how such charges could be applied in the case. "You don't, under RICO, have to have a formal, sit-down dinner meeting where you eat spaghetti," she said, seemingly invoking a scene from Goodfellas. "But what you do have to do is all be doing the same thing for the same purpose. You all have to be working towards that same goal. In this case, the goal: inflate test scores illegally." Most of the educators took plea deals. A dozen went to trial, and 11 of them were found guilty of RICO participation. 6 of those people are still appealing their convictions. Bruce Harvey, a well-known Atlanta criminal defense attorney, represented one of those who was charged, a principal accused of changing test answers, who ultimately received 2 years of probation. A witness claimed that the principal made the alterations while wearing gloves, to avoid leaving fingerprints. Harvey's client said that she had changed answers solely for the purpose of making district testing targets that determined whether or not schools would be shuttered. Harvey disputed the propriety of using a RICO law to threaten prison time for teachers trying to make sure that local schools didn't close. "This is more mouseketeering than racketeering," he said at the time. Traditionally, a racket is an illegal money-making scheme. The federal RICO statute, which was introduced in 1970, allows prosecutors to threaten serious penalties for people whose own criminal violations may have been relatively minor but who were part of a larger racketeering enterprise, such as the mafia. The threat of those penalties can prompt low-level figures to make plea deals, helping prosecutors generate evidence and testimony to use against those at the top of the hierarchy. The usefulness of such evidence makes RICO cases attractive to prosecutors despite the difficulty of trying multiple defendants with multiple charges all at once. "You could charge the same acts individually," Harvey told me, "but the evidentiary benefits to charging these kinds of RICO cases outweigh the complexity and clusterfuckism of having 20 people on trial at the same time." Georgia created its RICO statute in 1980, less to target the mafia than to go after black street gangs and non-traditional conspiracies, as Norman Eisen, a former trial lawyer and a senior fellow at the Brookings Institution, put it to me. The Georgia Assembly cited the need to address the increasing sophistication of various criminal elements. But the Georgia law didn't require prosecutors to demonstrate an underlying criminal enterprise, only the commission of a range of illegal acts that furthered a single criminal goal. Because of its breadth, Eisen said, Georgia prosecutors are more prone to utilize their criminal RICO provision as a vehicle for major cases. It's one of the best places in the country for deploying such a provision, he added. Vulcan Topali, a professor of criminology at Georgia State, told me that the state's generous statute helps create a whirlpool effect in the prosecution of criminal conspiracies. If you capture one person in the whirlpool, everyone else gets sucked in along with them.